Today in this video we'll be dealing with the non-pricing practices on the particular topic exclusive dealing agreements. So in the earlier video we have discussed about pricing and non-pricing practices of abuse of dominant position, which is being stated in article 102 of TFEU of EU law, and under section 18 of the UK law it has been determined what is known as abuse of dominant position. So here in this video we'll be particularly dealing with exclusive dealing agreements. Now what exclusive dealing agreements basically means that the customers are tied up in a particular way that they are contractually obligated, wherein they are required to purchase specific goods or services exclusively from a particular supplier for a particular period of time. So when that condition comes in for a particular period of time, you are liable to get a contractual obligation with a particular supplier, and you have to buy certain products or services from that particular supplier only, then that can be considered as exclusive dealing agreements. Now the variation of time can depend and will vary from case to case. Now, there is an interesting case of Hoffman-La versus Commission of European Communities, in which it has been stated that when the dominant position is using its position, when the undertaking which is in the dominant position is using its position doing such contractual obligations, even though other party willing to do it, but if it is stopping new entrants or the competitors to have a contract with the other customers, then actually this is having abuse of domination and the abuse of dominant position, and this can be considered the same. So under EU law, article 102 subclause 2 subclause C basically deals with the same. So as we have discussed earlier about the same. Now basically when we are talking about the exclusivity, it can be divided into two categories, that is the exclusive supply obligation and exclusive purchasing obligation. Now exclusive supply obligation basically means that the supply is restricted from supplying the service or goods of any other party, and this can be supplied to only specific downstream customers. So this cannot be supplied to any other person, and you are specifically concerned that they can be only given to specific customers. Whereas exclusive purchasing obligation basically means that the purchaser or customer is restricted from acquiring goods or services from particular supplier only. So there the supplier can give only to particular person, and in the second of exclusive purchasing obligation, in that it means that he can take the service or goods from particular supplier only. So these are the two things. Okay, so there is one famous case of the Intel versus Commission case, in which it has been held that what can be lead to dominant position, and what are the factors which can be considered by the Commission while taking into consideration about the same. We will not be detailedly dealing with the case, and there are some other judgments of EU courts as well which we can refer here, that is Telia Sonera Severage case, under which this is the most highest highest fine case in the Sweden court, and this is because basically what they did was they had a margin squeeze. Hence the competitors were not able to give that much margin squeeze, because they were giving their products in so much low rate, and they were not even earning profit. So under this case the Commission held that they were using abuse of dominant position, and they were held liable for the same, and had a high penalty of $, I guess, around 144 million. So it is a high price, right? Then again in the another case, what happened was, this is of course Denmark case, in which the same margin squeeze was there, but however it has been noticed that the average total cost was above than the average variable cost. Okay, so when such differences is there, then that cannot be considered as abuse of dominant position. This has been held by the Commission. That has in the principle. So margin squeeze, even though there is a margin squeeze, but if their average total cost is more than or is above than average variable cost, then that cannot be called as dominant position. Then so in the various cases the approach of Commission has been differed, and basically what they look after is the margin price, whether the margin price which is there if giving a profit or not, even though they are attracting the rival customers. But if they are not doing so much variation is not there, and their average variable cost is above than average total cost, then there is no any such issues, and that is a basic thing which is looked after by the commission. Then we have other 2 points which we need to cover, is that whether there is need of contractual exclusivity. So it is not always needed, even though there is no contractual exclusivity, but your act is such that it leads to exclusive dealing agreement, or kind of such it happens to be have such conditions, then that can be considered under the exclusive dealing agreement. And then whether it is long term, whether long term is needed or not. So the term is as such not considered as an abuse of dominant position, but however, if that long term is affecting the competitors from entering into the market, or the new entrants entering into the market, or if it is prejudicing the customers, then of course that will be considered as abuse of dominant position. Then we have two cases which we need to cover under UK. That is the Eriva versus Luton Airport case. In this case, basically what happened was, the National Express exclusive right to provide bus service from the airport to various London locations were given. So that was that they were not giving to any other people. So that will be considered as an abuse of dominant position. And secondly, the case of EWS called Hewlett contracts. In this case also, it happened that there was long-term agreement, and the owners were power stations. So the owners owning the power stations, so that's why it has been held that there was abuse of dominant position, and they were exclusively giving their customers really at low rate the calls. So that is how it was covered. Thank you for watching this video.